thank you all for joining us. We're really excited to have Adam Greene, our HIPAA expert for today on the session. And we've, as you know, we've been asking guys all the different questions that you want to make sure that we're asking him. And he's here and he's going to help us out today. I just want him to do a quick introduction, though, so that you all have an idea of his background and what he brings to the table. And then we'll go ahead and get started so we can use the hour to the best of our abilities.
Hi, thank you for having me here today. My name is Adam Greene. I'm an attorney with Davis Wright Tremaine in their DC office. I do health information, privacy, and security law. And prior to joining Davis Wright Tremaine about 7 years ago, I used to do HIPAA over at the U.S. Department of Health and Human Services. I'm very excited to be here.
Now, Adam, I have to ask you, first of all, thank you for being here. This is awesome. We're excited about this. When you say you worked for the Department of Health and Human Services because you were doing HIPAA, what does that mean?
Sure. So my first 4 years there were within the Office of General Counsel. So I essentially was one of the lawyers to the department on HIPAA matters. And so that covered things like I drafted the first HIPAA settlement agreement and negotiated that on behalf of the government. And then I advised the government on the implementation of the HITECH Act, a 2009 law that expanded HIPAA. And then my last year was actually within the Office for Civil Rights at HHS, which is the agency that administers and enforces HIPAA. And there I was the Senior Health Information Technology and Privacy Advisor, which what that meant was I provided guidance on applying HIPAA to really any new technology ranging from electronic medical records to things that we don't consider particularly new, like texting or even sometimes email. So that's what I did over at HHS.
Okay, so lots of good background that pertains to the things that marketers and people doing social media marketing actually would look to you for. So this is fantastic. So we also have Joe Hopscheid on the line, and he and I are partners in 11 Doctors. And so we're going to go ahead and conduct this interview. Joe's going to be watching the comments as they come through to see if there's anything that we can pull out of there for additional questions. We do have the questions basically that everybody sent us, and so we're going to try to use the hour to get through the frequently asked questions that y'all sent us. And the first one that if you see me looking off to the side, it's because I'm actually looking at the questions that came in, so I can make sure I'm asking them right. So the first one was, from a social media marketing perspective, we do a lot of lead generation. And Adam, you and I have talked about this a little bit. It's about, sending an ad out through Facebook or some other platform and basically offering some kind of an offer to whoever wants to take us up on it for, like $1,000 off of Invisalign or, some product or service that a healthcare provider is offering, just trying to generate leads that will hopefully turn into new patients. And so the first question that we have is, does HIPAA even apply to social media marketing since leads aren't even patients yet? So can you kind of give us an idea of how that question should be answered?
Sure. It's a great question. So HIPAA applies to what's commonly referred to as PHI, protected health information. And what's most relevant with respect to protected health information is the health information part of it covers information relating to physical or mental condition or relating to past, present, or future provision of health care. So the fact that someone is seeking health care would seemingly relate to the provision of health care and therefore qualify as health information. And so the other side of it is if that is being obtained on behalf of a healthcare provider that is subject to HIPAA, then that would be potentially subject to HIPAA. Now would be a really good time for me to throw out the disclaimer that this is for educational purposes and I'm not providing legal advice to everyone on the phone.
So I always tell people that you're my lawyer, but you're not their lawyer.
Exactly.
Well, one thing, I was actually kind of surprised. My wife is a lawyer, so I thought that would come earlier. But the situation really is, I hear from a lot of marketers that I talk to is they're not patients yet. Why would they have any rights? Can you say something to that?
So can you, expand past, present, and future patient, because the future patient thing gets a little bit hard to understand.
Yeah, I'll talk about both the legal and then just the common sense. On the legal side, the definition is past, present, or future, relates to past, present, or future, and so that could be, certainly a future appointment for healthcare, but future could certainly cover an interest, seeking to obtain healthcare when that information's in the hands of HIPAA-covered healthcare provider or someone acting on their behalf. The common sense side of it is just imagine if I was an HIV clinic and I figured, okay, everyone who goes to my website and is interested in HIV information, interested in potentially getting an appointment with me in the future, I'm going to go ahead and publish that publicly. You can imagine that wouldn't go over well with the regulators. And so, they have a vested interest in making sure that when people seek information about healthcare, that is protected.
Okay, so basically, even if they're just giving you their email address, which seemingly it doesn't seem like health information, but if they give you their email address in the context of a future provision of care, meaning, yes, I would like that coupon for that X number of dollars off that service, then that counts as protected health information? Right.
So protected health information is generally going to be individually identifiable and health information. So the individually identifiable, an email address clearly counts. Sometimes it'll actually have the name and the email address, but regardless, it's considered individually identifiable. The health information side would be if you take that information, like an email address, and if it is in any way tied to a healthcare provider, including trying to obtain services from that healthcare provider, if that healthcare provider is subject to HIPAA, that's going to be considered health information. That's going to be subject to HIPAA.
Okay, so from a marketing perspective, I'll just put it kind of in layman's terms, how we talk to each other. If you're doing lead generation for a medical practice owner that falls under HIPAA, and you're putting out ads for products or services for that healthcare provider, then essentially anybody who opts into that ad, at the moment they opt in, they are creating protected health information, and everything you do needs to be HIPAA compliant. Your business, your campaigns, all of the stuff around it. Is that correct, Adam?
That's accurate, yes. You are, once you have information that someone is interested in a particular healthcare provider who's subject to HIPAA, welcome to the world of HIPAA yourself, if you're collecting that on that healthcare provider's behalf.
Okay, can I just throw something in there? When we announced that we're going to be on a call with you, I had somebody say, well, you're just going to make him say what you want him to say. As a marketer, the marketers are all out there saying, well, everybody is doing it, so why would this be true? You're the only one saying this. Can you say something to that?
Well, I think there are areas of HIPAA that the regulators haven't necessarily had visibility into yet. And so you sometimes have areas, and this is certainly not unique, where it's falling under the radar and the regulators may not have had opportunity to see it, and misconceptions start prevailing. People start taking the view, I'm not subject to HIPAA, that sort of thing. And it really only gets changed sometimes when something, there's a patient complaint or something like that leads it to a regulator, and suddenly everyone jaw drops when they discover everything they had thought was true. The regulator takes the complete opposite view. So, I would say, in this area, if and when a regulator starts, finding out about, lead generation, which is not necessarily something that's been on their radar in the past, that's when you might start seeing a pronouncement or some change.
So basically what we're saying is that you're just a breach away or just a complaint away from a regulator coming and looking. That's what you're saying there, right? As soon as something serious enough happens, then they're going to come looking.
Yeah, I don't want to preach fear, uncertainty, and doubt. This does have to essentially make its way in front of a regulator somehow. And certainly what you said, a breach would be a good example of that, where, suddenly the, information gets exposed to the wrong person, and that's when everyone starts looking under a microscope and realizing, oh, we have to report this to a regulator. And that's when suddenly this falls under scrutiny. or it could be a whistleblower within the organization that leaves, fired employee. I've seen situations like that get in front of a regulator.
Or competition. Does that happen?
Yes.
Ouch. I mean, as a nurse,
it's certainly possible.
Yeah, that's not fun to hear about. Along those lines too, I think in October during the annual convention, HHS OCR made an announcement that they were turning a focus to three things, two of which really kind of apply to us, which was social media and texting. So is it safe to assume that if they're turning their attention to that and looking to provide future guidance on it, that there's got to be somebody somewhere right now who's taking a look at how things are done in those areas, and we can expect that people are looking at that right now in order to provide that future guidance, right?
Yes, I mean, and the person looking at it is essentially the person who took over my job after I left. Okay. So, social media was one of three areas: social media, texting, and encryption that they've said they want to put out upcoming guidance on. Now, social media and lead generation are two different things. So, I expect that they're going to be getting into issues like, can you communicate with patients over Facebook messaging, things like that. It'll be interesting to see how much they actually answer and whether it gets into things like lead generation and how many more questions any of this guidance raises.
Yeah, absolutely. And we've seen a lot of stuff happening, at the state and the federal level around various, cases that have been filed. I mean, Facebook's name is all over the place. I'm sure you get the same notifications that I get all the time about different things that are happening with Facebook. Consumer privacy just kind of seems to be trending right now. I saw something just yesterday about the state of Washington trying to pass a new Consumer Privacy Act, and we know California just did theirs in a record 7 days. So there's a lot of stuff going on, and I think that's really what, why Joe and I are so passionate about talking with people about this, because yes, you're right. Maybe a marketer hasn't been crucified yet, but that doesn't mean that it's not going to happen. And do you really want to wait until, something bad happens before you start taking a look at how this all affects your business? So that, we have several questions for you today, and we can keep going with those unless Joe or Adam
the next question is really, when it comes to that, if something happens, is the doctor the one that's liable or is somebody else?
Right.
Before I get there, let me just touch on something Kristen said, because I think there's actually a really surprising flip side to to this whole conversation, which is that everyone over the past 10, 15 years has been really scared of HIPAA and running. Can we avoid HIPAA? I don't want to deal with HIPAA. I don't want to be subject to HIPAA.
I'm ready to raise my hand on that one, Adam, because I was one of them when I went into marketing. I did not want to go into healthcare for that reason.
Yeah, well, oddly enough, HIPAA may be your best friend now, and I'll explain why. So exactly based on what you said, with Facebook, Cambridge Analytics, all the headlines that we've been seeing has led to legislation at the state level, and they're looking at it at federal level, that to really provide additional privacy rights. And the biggest one so far is the California Consumer Privacy Act, or CCPA for short. And it changes the way you have to do business entirely. Suddenly you need to know what information you have on an individual, where it came from, where it's going. Individuals have a lot more rights, and there is an exception that if you are a business associate and the information is protected health information, it is not subject to the California Consumer Privacy Act. And so I've had conversations with entities or in California who a year ago were trying to get everything out of HIPAA, and now they're suddenly trying to get everything back into HIPAA because they'd much rather be dealing with HIPAA than CCPA. And so we may find actually that HIPAA is a lot, is the better alternative sometimes.
Mm-hmm.
Wow.
Okay.
Wow. So Joe, you had a question about the accountability, because I'm looking at my list of questions here, and that's one of the ones that came in commonly. Doesn't the accountability lie with the doctor?
So the way HIPAA works is you've got what's called a covered entity, and that's going to be usually a healthcare provider or a health plan, and then you've got a business associate. And a business associate is someone who handles protected health information on behalf of a HIPAA-covered healthcare provider or health plan. And what the covered entity, the healthcare provider, has to do is put in place a business associate agreement with anyone who qualifies as a business associate. That's their main job. And if they haven't done that, the Office for Civil Rights, the agency that enforces HIPAA, they have in a number of cases imposed significant penalties on healthcare providers or health plans for not having those business associate agreements in place. But the business associate is also subject to much, not all, but much of HIPAA. Now, if the business associate did not know, go ahead.
I just want to clarify, when you say business associate, are we talking about the marketer? Are they a business associate in this case?
If a marketer has information about individuals that they are maintaining on behalf of the healthcare provider, then yep, that would generally, I'm a lawyer, I always have to avoid absolutes, would generally put them under HIPAA.
But doing the lead generation that we talked about earlier, if they're collecting name, email, and or phone number on behalf of the provider in the context of future provision of care, so an offer of provider's product or service, then that's what makes the marketer a business associate. Is that correct?
That's correct. And so, the regulator is going to look to the healthcare provider and say, do you have a business associate agreement? And they're going to look to the marketer and say, did you know that you were a business associate? Were you in compliance? If you had no possible way to know that you were a business associate, that may be one thing. But if you are a marketer that's specifically catering to healthcare, then there may be a regulator is going to say, okay, you're a business associate, you should have complied with HIPAA.
Okay. I just want to pause here, Joe, for a quick second and just ask everybody to help us get the word out on this live and put a hashtag live in there if you're watching this with us live, and do a hashtag replay if you're watching it as a replay later. Just help us kind of get the word out, and then, hit the likes and the heart button and all that. We got to play the Facebook game, guys. Really appreciate you helping us with that. If this is something that you find valuable, please help us by doing the hashtag live, hashtag replay, and hitting those likes and hearts so that we can get it out to more people and they can also get the same value that you're getting. So I just wanted to get that out there for a second. So we were talking about the accountability lying with the doctor, and you were saying that the marketer is actually a business associate, so the marketer has some accountability too. Can you explain what kind of accountability the marketer has? I know there was something that happened in September of 2013 called the Omnibus Rule, and I just want to understand how that affected the business associate, if that's something you can help us understand.
Sure. So, a business associate, such as a marketer that has lead generation or other information on behalf of a covered entity, they have to comply with all the security rule, which is essentially about 50 or so categories of controls. Some of the privacy rule that says how you may and may not use and disclose protected health information, and they have to comply with the breach notification rule. And once again, I try to avoid the fear, uncertainty, and doubt. I want to play it straight here. Most cases are handled through voluntary compliance, meaning the government comes and works with the organization to fix it. But the exposure is that for each day that you are in violation of any provision of HIPAA, as a business associate, for example, as a marketing company that if you qualify as a business associate, it's roughly $55,000 per day, capped at $1.7 million per calendar year for each violation. So if you imagine 50 different requirements, that's $1.7 million times 50. Now, am I saying that the government's going to come after you for $80 million? No. But what happens is most times they resolve things through just voluntary corrective action. But sometimes they'll say, okay, we found these violations. We can impose penalties on you for $20 million, $10 million. We're willing to settle with you for X. And that X has been averaging about $1.6 million, which some of the larger institutions, it's $5.5 million, or even $16 million in one case recently. Smaller institutions are less.
Okay.
So why is it less? Are they looking at, they can't afford more, or why are they going lower?
They've been very clear. They're not looking to put anyone out of business. Okay. They're looking to really do two things. One, where they feel like there's been such systematic non-compliance that they feel like they need to send a message to that entity, that covered into your business associate. They don't want to put you out of business, but they don't want you to, pull some money out of your back wallet and move on. They want it to have an impact. And then they also, there's been about 63 cases or so, roughly, where there has been financial enforcement, and those get publicized, and they're looking to really send the message. So, they had one a few years back where someone had a patient testimonial on their website without a HIPAA authorization. It was a small healthcare provider. They settled for a relatively small amount, but they wanted to send the message to the industry. Don't do that.
Absolutely. You know what? And Joe, if you just take a note and remind me, I will post the information on that particular fine in our group. That's something I was actually looking at yesterday.
I've seen in September too that they actually did a $1 million fine on 3 hospitals because they did some videos with patients in where they didn't get the authorization before they actually went out and did the videos. Do you know anything about that, Adam?
Yeah,
that was Boston.
Not to pick on ABC, but there's now been 4. There was New York. There was an ABC Dateline show, New York Med, that led to a settlement with New York Presbyterian a few years back, and then there was a Dateline series, Boston Med, where the one that you're referring to, they settled with 3 Boston healthcare providers.
But
and
they didn't fine ABC though. Why did they just fine the healthcare providers and not ABC?
Well, their ABC was not acting on behalf of the healthcare providers. I mean, it's not like the hospitals went and paid ABC to create marketing videos for them, for example. There, the issue was that the hospitals, they may have thought that as long as what ultimately goes out the door is de-identified, we're fine. Meaning that the video that ends up on Dateline or wherever, they might have thought that as long as that's blurred, it's not an issue. And the message that the government sent was, no, allowing news media into patient treatment areas and giving them access to protected health information without a permissible purpose, such as having the patient sign an authorization, that's a problem, even if the end result that gets televised is blurred or something like that. And so
is that also
anytime
to the marketer as well? Because a lot of marketers, I mean, we have clients right now who have their own videographers, or they have, subcontracted the services of videographers who will come into, the provider's office, their practice, and do all kinds of videos. Some of them involve patients, some of them don't. Of course, we'd have to have the proper authorizations. But if they're even coming in there to do videos, how does this play into that context?
So
from that case,
there was some guidance after the New York Presbyterian case. The government put out some guidance, and they mentioned kind of that exact situation. First in that guidance, they distinguished between treatment areas versus kind of public non-treatment areas. So having a news crew in the emergency room is different than having a news crew in the waiting area, where the general public is allowed to be. And then to your point, later on in the guidance, they say, it's not just news media. If a healthcare provider brings a video crew for purposes of creating their own video, that would require a business associate agreement and would create a business associate relationship. Now, I think it's going to depend on if you have a video taken outside of your office, that's not going to involve any patient information versus if you have it, smiling patient, in a treatment area, that's a whole different story.
What if it's just smiling patients on a bulletin board, like pictures of people, happy patients, and that happens to be in the background while you're filming? How does that play into it?
So any information that would identify someone as a patient is really going to be protected health information. And so you're going to run into 2 issues there. One, the marketing company is going to qualify as a business associate. The provider will need a business associate agreement with them, and the marketing company will have to treat that information as subject to HIPAA. And two, you're going to need to have an authorization of, before you post video that would identify someone as a patient of the doctor, you need to get their authorization. Frankly, not even before posting the video, before taking video of, that has them as a, patient, you should be getting that authorization.
Okay, interesting. Quick call out to the audience again. If you guys are enjoying this, let us know by hitting the heart button or like button. We want to get this information out to people and do the hashtag live, hashtag replay, all that kind of stuff. Joe and I don't like to spend too much time on that stuff, but it's an important part of getting this.
Well,
this out
the reason I'm laughing is because if you're enjoying this, I'm as a marketer, I'm sitting here right now, and I'm not enjoying what I'm being told.
I know.
I try to be even-handed, but it's amazing how many people go out for drinks after I speak.
Oh my goodness. Yeah, well, Joe and I are in two different states, so we can't even console with each other. So I have a question. You were talking about how the marketer would be a business associate and to come in and do the video, assuming you're in a patient care area, which a lot of the marketers that I've worked with, they will go into a treatment area and they will do videos in there with their practice owners. The videographer, you and I've talked about this, Adam, about how the videographer plays into this whole thing as a subcontractor to the marketer. I'm the videographer. I come in and I'm going to go ahead and shoot that video. I'm going to take it back to my office or wherever. I'm going to edit it and, furnish it for marketing purposes. So let's assume that the patient has signed the authorization and the authorization has all the right language in it to make sure that, we can use this information for marketing purposes. How is the videographer seen in all of this? Are they a business associate or is there some other way we can classify them so that we don't have to have every videographer we work with be a business associate to the fullest extent?
So HIPAA provides a bit of a choice there that when you have a contractor, you can either treat them as a business associate, in which case you have to enter into a business associate agreement with them. So you get a BAA, as it's called, with the videographer, and they are expected to fully comply with HIPAA. Or alternatively, you can treat them as a member of your workforce, as if they were one of your own employees. And then you just have to, like all your employees, they train them. They have to be subject to appropriate policies and procedures. So that's the legal side, and it's always important to keep in mind the common sense side. I mean, the way these things play out is you bring in the videographer, and then they go and see a friend and said, "Oh yeah, I saw your sister over at the doctor's office last week," and the sister, suddenly someone's furious and complaining, and that's the way these things kind of play out sometimes.
Yeah, Joe has a.
Yeah, I don't think we should go into that story. I can tell that later. My assistant actually had a boyfriend who dropped her, and she saw the new girlfriend on a plastic surgery list, and didn't keep it to herself. That was actually a really bad situation for me, but.
And Joe got a call from the plastic surgery.
Yeah, frankly, I was really happy the way it played out, but it made me realize that I am accountable to my clients and to their patients, that I can't just play ignorant. And
it's true. Yep.
Those situations, that's actually why Kristen and I go into this, because I think I've made a lot of mistakes in the last 15 years in my medical marketing career when it comes to that. And that's why we're teaching this, because it is possible to do it right without stepping from problem to problem.
Well, I'll tell you a quick story that also I think illuminates this, which is, I won't name the healthcare provider, but a California healthcare provider engages a business associate. And that business associate engages a subcontractor business associate, and this is related to marketing. I admittedly don't know the details, but I do recall that either the business associate or the subcontractor business associate was involved in doing some marketing. And through this, there was a patient list that got shared from the healthcare provider to the business associate to the subcontractor business associate. So the subcontractor business associate goes and looks to hire someone and goes ahead and, as part of a test in the hiring process, gives an applicant the
Oh,
list
no.
of patient names.
Okay.
And it says here.
Oh, wow.
Adam, are you still there?
Uh-oh. Did we lose him? That was a good story.
Yeah, I think we lost him. I'm gonna add him to the call again.
Okay. Hang in with us, guys. I want to hear the end of that. I have not heard that story. Holy moly. Some of the things people
You've
do.
reached the voicemail of Adam Greene at Davis Wright Maine.
Oh.
I'm not available at the moment, so please leave your name and message, and I will get back to you shortly.
Record your message at the tone. When you are finished, hang up
No,
or
I
press
don't.
pound for more options.
I don't know how to hang him up. I think
Adam, we lost you.
Okay. I'm gonna see if I can add him again. But
All right, hang in there,
you know, this is something that I always say is if somebody's listening and they can't describe fast or transcribe fast enough, they
Hello. I see that we got dropped.
Oh, there
yeah.
we were like hanging on with bated breath, Adam. We were like, what is the end of that story? Oh my God.
Okay. So did we get up to it being posted on a website before I got dropped?
No. No.
So the job applicant goes ahead and was given this spreadsheet and told make a bar chart out of it or something like that, and goes on to like studentforhire.com, one of these websites where you get help, paid help with your homework or whatever, and puts it out there and says, can anyone help me make a bar chart out of this? And at the end of the day, someone goes and Googles themselves and finds that their information is up there on this website, and it leads to a $4 million settlement between the healthcare provider, the business associate, and the subcontractor who had handed this out to a job applicant and who the healthcare provider had never even heard of the subcontractor, had no idea that this subcontractor even had their information. So moral of the story, be careful in California in particular.
Well, I want to know who was liable for all that. How did the liability fall in that chain of events?
So I don't know is the answer. What happened was there was a settlement that involved all three. Of course, the healthcare provider made the headlines, and it's not till the third paragraph that you get to the other ones. But my understanding is the settlement was with all three, and the way I would expect that it probably worked is the healthcare provider probably sued the other ones to get as much of that $4 million as from the others that were more at fault as possible. But whether they were able to get much is a whole different question.
Right.
Yeah.
So can we take that into the whole list question we get all the time, Joe, where people are always asking us, can I
upload my patient list to ClickFunnels?
Well, first they want to know, can I get a list of patients from my doctor? And then the second thing they want to know is, can I upload that list to Facebook and create a custom audience so that, we can market to them or create a lookalike audience eventually so we can market to people like them, right? And so you and I, again, have talked about this, and this is kind of a gray area, and you have said in the past that the likelihood of enforcement is low, but can we talk about that a little bit?
Sure. So a list of patients, there's some pretty clear guidance out on this.
Adam, can I interrupt you when we talk patients? Yeah. Does that include leads, future patients?
Well, so the guidance is, one piece of guidance talks about a patient list, so current patients. Okay. Another piece of guidance says any individual identifiable information tied to a covered entity should be treated as PHI. Now, there's no guidance out there specific to lead generation. So, while that second piece of guidance I referenced certainly could be read to include it, we just don't have anything concrete where if the words lead generation, for example, are talked about. But I would say, there's a very strong argument that that's going to be protected health information. And to then, navigate, it becomes a question as to what are you providing Facebook, for example. If you're providing Facebook a list of email addresses and Facebook has no idea whether these are patients or potential future patients of a particular dentist versus they might be people interested in new Hondas. Facebook may have no idea what this list relates to. There's an argument to be made there that, well, we're not disclosing protected health information to Facebook because there's no health information. They don't know what context this is in. And then the other argument, though, is even if they don't know, does it still relate to the past, present, or future provision of health care? And so, there's some risk there that even if Facebook has no idea what these emails relate to, that if a regulator ever learned of this situation and scrutinized it, they would say, hey, this was obtained in the course of people inquiring about healthcare services, so this relates to the future provision of healthcare, even if Facebook didn't know what they were getting. And so it's a gray area right now, and it becomes what's most important. And my role as an attorney is not to dictate what you do and don't do. My role as an attorney is to make sure people understand when they're taking on risk and what level of risk that is. And so it's important to understand, you may have arguments that this would not be subject to HIPAA when it's being disclosed to Facebook in this fashion, but you have to understand that a regulator could view otherwise and what level of risk you're taking on.
Well, see, Adam, what I always say when Kristen comes with this de-identified thing is my argument is that you can't de-identify, because what you do is you upload a list to Facebook, you create a custom audience, and then you run healthcare provider ads towards that custom audience. It's pretty clear that I'm not selling a Honda at that point.
So wait, it's not de-identified. What we've talked about is breaking the chain. If you're uploading a list of current patient email addresses into Facebook to create the custom audience, does that effectively break the chain between the list of emails and the connection with the healthcare provider? And so that we've discussed as a gray area. I don't think that falls under de-identification, but I'm hoping that it falls under breaking the chain.
Right. Well, going back to what is PHI, it has to be both individually identifiable and health information. And so de-identification gets towards whether it's individually identifiable.
Right.
We're not saying that this is necessarily not individually identifiable. The argument would be that it's no longer health information but I think you raise a good point, Joe, that while Facebook, if they simply receive that list, may have no idea whether it's patients, people interested in health, who are seeking health information versus people seeking Hondas, it raises a question when you start using it on Facebook, specifically in the healthcare context. Even if you might have broken that chain, that it wasn't, arguably wasn't health information at one point, does it become health information once you start using it on Facebook to send out healthcare campaigns?
Right.
So it raises an interesting question for sure.
There is the next step to this is that people also upload email lists into follow-up tools where they don't have business associate agreements with, and there are several of them. Actually, after the call with you, we wanted to go into a Zoom and just show how to do your due diligence to see if you have a HIPAA compliant tool. But can I take a list of 8,000 patients or patient leads and upload it into a tool where I don't have a business associate agreement with, and then start running email campaigns towards these patients or towards these prospects?
Like MailChimp or all the customer relations management tools, whatever it is. The money is in the list when we're talking marketing, Adam. So the goal always is to use the list to the best of the advantage for marketing purposes, right? So we're always trying to get a list somewhere where we can target people. And where does that fall if we want to take that list and load it up into a tool and then use it for marketing purposes?
So, and I know how frustrating dealing with lawyers can be, because I'm going to say it also falls into a gray area. Yeah, if you have a list, and let's say you bought a list, and that list was not tied to healthcare before. That list was, I just want to know everyone who's got these different traits. And I now, on behalf of a healthcare provider, start sending communications to that list, trying to get them to obtain, to come to me and get healthcare from me, to, get dental services or whatever from me. There's an argument that, at this point, no one has yet shown any interest in becoming a patient. You're just sending out emails to them. And so it's not PHI, it's not subject to HIPAA. The risk is that if you get a particularly aggressive regulator, they may say, well, this relates to future provision of health care because that's the whole point that you were sending the list, or that you were sending the communications, was to get them to partake in health care, to try to get that. So, I think it falls under a gray area. There's certainly arguments that it's not PHI, it's not subject to HIPAA, but my job is to make sure my clients, which, good reminder, this is for educational purposes, not legal advice, but it's a good, it's important to understand where there is some risk.
Mm-hmm. And if we're talking about a bot list there, what if it's a patient list?
I mean, if you are, HIPAA was very much built around the idea of not going ahead and selling patient lists, for example.
Okay.
That
was
one of the drivers.
I'm not selling the list. What I'm doing is I'm taking a list and I'm uploading it into a tool, and that tool then helps me send out emails, other communications. And my question actually was geared towards the difference between a tool where I have a business associate agreement with that actually provides HIPAA compliance and a tool that says outright they're not HIPAA compliant.
So if you have a third party that's providing that tool, I mean, if you're running the tool locally, that's one thing. But if it's a software as a service-based tool, for example, where there's going to be some other party who's going to have access to this patient list, then that at least raises the HIPAA issue. Mm-hmm. Now, I hate to get into really complicated areas, but there's something called a conduit exception where, kind of like Federal Express or an internet service provider, if they're just transmitting information from point A to point B, then they don't qualify as business associates under HIPAA. And so, if the tool is just serving as a conduit, just transmitting information from A to B, it may fall outside of HIPAA. But if it's actually accessing protected health information, if you've got some third party who's actually taking that patient list and transforming it into particular messages, then there's a significant risk that that's going to fall under HIPAA, and that that a regulator would expect you to have a business associate agreement with that third party, and that they'd want to see that things like encryption are in place in that software tool.
Okay.
So do the software vendors in that, so let's say we use lots of tools, Adam, as you can imagine. We use, landing page builders, and we use integration tools, and we use email, providers, so we can send out email. There's so many things. What I want to understand is this information, this leads opt-in information. It goes into, let's say, ClickFunnels or Lead Pages, which I don't know if you're familiar with those, but they're landing page software, and there's opt-in forms in there where the person actually puts in their contact information in that context of future provision of care, right? So that contact information then goes into maybe an email list right within that SaaS, that software as a service vendor. And then maybe even through that same SaaS, we can send out emails to those people, or it creates a profile for them. There's all kinds of stuff that can be done in these tools. If those tools have access to that information in that context, do they have to be HIPAA compliant?
So the question is not whether they have access. The question is more whether they actually are accessing the patient list, and rather than just transmitting it.
Does that include if we call their help desk for assistance and they can get into our account to look at something with us?
I mean, so troubleshooting would definitely, if they, there's actually guidance on software vendors, and they talk about if a software vendor hosts protected health information, or if a software vendor may access protected health information in the course of troubleshooting, then the software vendor would be a business associate. So those sorts of activities certainly, you're really looking at, are they handling PHI more than just transmitting it from A to B? And if so, then they're likely going to be a business associate. But it can be a tough analysis, admittedly.
Okay. So let's say we're using a tool that does have access to the information, because they do. And frankly, I'll just be honest with you, some of the tools go further than just having access. They actually they tag and they pixel, and if you run Chrome extensions behind the scenes, you can see that some of those tools are actually doing more with your data than you even realize, right? So if I was going to use that tool then for lead generation to get the opt-in, to send out the email, to store the lists, that kind of thing, I would have to have a business associate agreement with the software vendor as the marketer. Is that correct?
So generally that's accurate, yes. And so you could be found at fault under HIPAA for not having a business associate agreement with a third party that you're providing access to PHI and is manipulating or running analytics on that PHI for you.
Okay. And then how does the government view the software company themselves in all of this? So let's say something happens. Let's say the vendor that I'm using to store those lists or, capture those opt-ins, let's say they have a breach. How does the government, if I have to have a business associate agreement with them, that means that they are a business associate under the law. And so how does the government view them if there's a breach in their system? So
in general, there was some guidance once for cloud providers that said, the regulator put out the question, what if you're a cloud provider and you don't even know that you've got protected health information? And the response was, well, you're a business associate regardless of whether you've signed a BAA and regardless of whether you know. But there's an affirmative defense where we cannot impose penalties if you take corrective action within 30 days. And that could be, the examples they provide would be getting rid of the information within 30 days or coming into compliance with HIPAA within 30 days. So, just kind of walking through the scenario you're describing, let's say you have a healthcare provider, and that healthcare provider has a marketing firm, does not have a business associate agreement in place with that marketing firm, and then that marketing firm is using a third-party tool and doesn't have a business associate agreement in place with that third-party service provider. So admittedly, the government's going to be most focused on that healthcare provider who did not get a business associate agreement in place with the marketing firm. The government will look at the marketing firm and say, well, what did you do when you found out? And if they find that the marketing firm knew that they were essentially handling health information, they may feel like you knew and you didn't correct within 30 days. If they feel like the marketing firm had no reason to believe that they're handling health information, then maybe they would say, okay, if you corrected it within 30 days. And the same sort of thing would then go down to that third party. Did that third party know that they were handling PHI? And if not, did they take appropriate action upon learning?
Mm-hmm. Interesting. Joe, did you have any other questions about that? Tools are a hot topic amongst marketers. So,
well, my question there is, I know lawyers don't like to speculate, but I want to see if I can get you to speculate a little bit. Facebook recently added something into their terms of service for Messenger, where they say direct communication between people and healthcare providers is prohibited. Is it possible that they fear the liability under these privacy laws, and that's why they did that? Or why would they?
I would say probable. I think a lot of technology companies face a choice. They either choose, okay, we want to cater to the healthcare sector, we will put in a HIPAA compliance program and sign business associate agreements, or we want to steer really clear of the healthcare sector because we're not HIPAA compliant, don't want to be HIPAA compliant, whether it's because of liability concerns or just they don't want to go through the compliance program. And what you see more and more of is, where they take that position of we don't want to touch HIPAA, they will put in their terms of use, do not store protected health information with us, or do not send us PHI, things like that. Do not use the platform for PHI.
And Amazon actually did something like that too, is they say if you store PHI, you have to have a business associate agreement in place with us in their terms of service. That's actually one of the things that I always say. What's going to happen is these tools, as soon as they realize that they face liability, they're going to ban us medical marketers off their platform because that's the easiest way for them to fix it.
Yeah, and we're seeing that. I mean, Facebook was the most recent one, and it's always shocking when we enlighten people on that because they have no idea that actually happened. And there's thousands and thousands of practice owners that have business pages in Facebook, and they have Messenger turned on. And so, what we tell them, and Adam, I want you to correct me if we're wrong, but we tell them that that's not only a HIPAA violation because Facebook's not HIPAA compliant, and you're allowing direct communication between a practice and a past, present, or future patient, which is going to be about, provision of care. I mean, that's just how those things are set up. And so, but it's also a Facebook terms of service violation because Facebook recently updated the terms of service to strictly prohibit that use of Messenger. Well, so you're going to get your account shut down.
Here's one other question that I want to ask. That comes up all the time. It's kind of funny. I'm married to a lawyer, so I would not come up with that question. But, if I have the piece of paper, if I find somebody somewhere that signs on behalf of the company that business associate agreement, and I know they can't be compliant, but I have the piece of paper, is that enough?
So the way HIPAA works is that a covered entity, so the healthcare provider, is required to enter into a business associate agreement, and then likewise the business associate with a subcontractor has to enter into a business associate agreement, and they don't have to proactively constantly monitor whether the business associate is in compliance. But if they actually find out for one reason or another that the business associate is out of compliance with the BAA, the business associate agreement, then they're required to take action. They're required to cure it, so get the business associate to fix the pattern or practice that's violating the BAA. Or if they're unable to get a cure, they would be required to terminate the agreement. And so from the healthcare provider, they don't necessarily get direct liability for the business associate violating the agreement. They do get direct liability, though, if they don't take action upon learning of the business associate, like the marketing company, violating the agreement.
So essentially, if as a doctor, I have a business associate agreement with a marketer, and I know that marketer is using some guy somewhere in India to generate my leads, that's a situation where I purposefully, I know the guy isn't compliant. Do I have to ask my marketing company to fix it? Do I have to get rid of the marketing company? How can I fix that?
So, well, first I'll throw out that having someone do the work out of India does not necessarily violate HIPAA. So that could be okay. But
so
assuming that for one reason or another.
Could I educate the person out of India on how to treat my PHI, and then I would be compliant? But let's say there is a situation where the doctor knows the marketing company is not compliant. How can I cure that as a doctor?
Then you have to work with the marketing company to see that they have fixed it and feel confident that they've fixed it, so that you can put down in your files, okay, we've cured this. And if you aren't able to reach a level of confidence that it's been fixed, then you'd have to terminate the agreement.
There is something in the breach notification rule that was added about having to report if you can't go and find somebody else to do it for you. I haven't asked you that question, but I think Kristen has relayed that.
Well, I posted it. I actually posted the language from hhs.gov recently, Joe. So what Adam is saying, I think, is along the lines of what I posted, which is the doctor at the time he realizes that this is a non-compliant relationship has to either fix it or terminate the relationship with the marketer. And if he can't terminate the relationship with the marketer and can't fix it, and because maybe there's no other option out there, then he's required to report it. That's the information that I have found on hhs.gov. So Adam, let me know if that's incorrect.
Yeah, I mean, there used to be a different requirement that if you cannot terminate your agreement after finding that your business associate is in violation, then you'd have to report it to HHS. That got removed in 2013. But I want to talk a little bit about this versus breach, because they have some overlap, but they're different. So you could have a business associate who's violating their agreement, but there's no impermissible use or disclosure of PHI. And in that case, you have to take action to get them into compliance and terminate the agreement if that's not successful. But you might not have a breach there. That would have to be reported to individuals if you're the doctor. Versus if the noncompliance leads to an impermissible use or disclosure of patient information, then besides getting them to cure the matter, you also may have breach notification obligations where you have to report it to your patients if you're the provider, to Health and Human Services. So there's going to be a lot of overlap, but they're not always going to be reportable breaches. And I'm going to have to jump off. I apologize.
Oh, it's 11. Oh, no. Goodness. I didn't even realize it.
We're already an hour in, so thank you, Adam, for talking to us and spending as much time with us as you have.
And Adam, if we get great, good feedback on this, which I think we already are just based on the comments, is this something that you'd be willing to do with us again?
Yeah, I'd love to talk to you about doing it again.
Awesome.
Okay.
All right. Well, thanks for having us.
So
yeah, we'll let you know we've got other stuff to do.
Okay.
Thank you, guys.
Thank you, Adam.
Thank you.
Okay, so after this, we're going to hop on a Zoom and talk a little bit about tools.
So yeah, we just want to invite. I'm still reeling, honestly. I learned a couple of things during that conversation, and I'm processing it. So I'm guessing there's a lot of other people doing the same thing. And I see a lot of thank yous to Adam. So I will make sure he gets that information, you guys.
So Scott has posted a Zoom meeting in the comments. If you can go and find it, I'm going to start that Zoom. And then
so
maybe we can also directly talk with people and ask that can ask us some questions, and we'll just hop on and maybe even show some stuff that we are encountering and how to do this due diligence, how to find tools and stuff like that.
Yeah. So for anybody who's interested in hanging with us, we're going to switch over to the Zoom link that's in the comments.
Yeah.
Can you verify it's in there? Because I haven't found it yet.
Yeah, Scott dumped it in there. Scott Harvey, just look at it, and I'm going to start that Zoom, but I'm going to go get a drink, so like 5 minutes. This is also only if you watch it live, of course, because we're not going to have a standing Zoom meeting. So thank you, everyone, to be here, and in about 5 minutes, we're going to be on that Zoom. So.
And we're going to be talking about tools.
Yep, we're going to be talking about tools, and this is not going to be shared besides the people that are on that Zoom.
Right. It'll just be private. We're not going to record it. We're not going to put it on Facebook. So if you want to be part of it, go ahead and give us a couple of minutes, though.
Okay. Yeah.
All right.
So,
thanks, you guys.
Thank you, and let's do this again.
Awesome. Bye.